Welcome to In the Courtroom and the Boardroom, Business Law and Litigation with Colleen McKnight.
Hello and welcome to In the Courtroom and the Boardroom, Business, Law, and Litigation with Colleen McKnight. I am your host, Kevin Rosenquist, and I'm here with trial attorney and founder of McKnight Law, Colleen McKnight. Today we're going to talk about when to settle and when to fight. Colleen, great to have you back.
It's so good to be back, Kevin. Thanks so much.
So what are the ways in which a case resolves or comes to an end?
Yeah, so we usually see it in one of three ways. Obviously, there's variation, but the parties can settle, which means they come to a resolution and agree to drop the suit. You can win on a dispositive motion. So you can say, hey, judge, as a matter of law, we win, or we've fully proven our claim and no juror could reasonably find against us. And then you can go to trial and get an outcome either from the judge or the jury. So those are really the three ways that we see most cases settle or resolve. And, each of them has their own strength and their own risks. I will say that summary judgment is pretty rare in Harris County State Court, but we do see it more often in federal court. So if you think you've got a strong claim and you can really prove it on the paper, you might be able to win without having to go all the way to trial. But in state court, what we usually see is either the parties reach a settlement together that they can both live with, or they go all the way and let the judge or the jury decide.
Without giving away any of your trade secrets, what do you look for when deciding whether a case should settle or if it makes more sense to head toward trial?
Yeah, so I approach every case like we're headed to the end, right? From the very beginning, one of the very first steps me and my team take is we figure out what are our claims, what are our defenses, what are our counterclaims, and then we go get what the jury charge is for those claims. And the jury charge is the set of instructions that will be sent back to the deliberation room with a jury at trial. So the jury has to decide, was there a contract here? Did we perform? Did the other side perform? Was there consideration for the contract? If they breached, what are the damages? And that essentially lays out for us, what do we have to be able to prove? What do we need evidence of? Where are weaknesses? What do we need so that when we begin, we have a really clear directive for our clients and we don't get caught on rabbit trails or tangents, and we can keep the client focused as well. So once you take that step and you know this is what we're going to need, you go to the client and you see, do we have it? Do we have gaps? Are there going to be issues? And oftentimes that will help us determine, is this a case we want to take all the way, or is this one where we want to settle? The other major consideration is, what does the client want, right? Do they want this done and they're willing to take a haircut or they're willing to give more so that they don't have to deal with it? That's a case we're probably going to try and settle for them because it takes time to get to trial and it can be painful and it definitely takes time. Other times the client has an appetite to say, I'm willing to fight this all the way. I was wronged. I've been accused of wrongdoing. I'm not willing to take a haircut or give less. I want justice. So you take it all the way.
Are there warning signs that the other side isn't serious about a resolution or might even be underestimating your client's position?
Yeah, some of those warning signs that I see the most often are really low ball offers.
Yeah.
Your claim is worth $10 million and they're offering you 50 grand. A lot of times I'll see clients or opposing parties refuse to exchange really critical information. And that's not only, hey, you're not taking it seriously, but also, what are you hiding?
Yeah.
Right? Why aren't you willing to hand over what you know we need to either prove you or us right? A lot of times I'll see opposing parties move the goalpost, right? Like I finally get my client on the same page and I think, we could probably live with this. And we come back and we say, okay, fine, we can live with this. And they say, well, also, we're going to need Z. And sometimes Z is an afterthought, right? It's non-disparagement. We don't get to talk badly about you in the marketplace, but sometimes it's very material. And that is very frustrating for a
Yeah, I
client
bet.
who feels like, yeah, they've gotten where they needed to go. And sometimes you just have somebody who refuses to accept the facts. I had one trial several years ago. I was actually 8 months pregnant with my oldest, and the plaintiff just wouldn't accept a reasonable settlement offer. He said, that jury is going to give me my money. And it didn't. And he walked away with nothing.
Mhm.
But you can't make a horse drink. You can just lead it to water.
All right. If someone has a really strong case, why settle rather than take it all away? Are there certain advantages in settling?
Yes, absolutely. So the major benefit to settling, I think, as opposed to going all the way when you have a strong case, is that settlement can give you things a trial can't. You can get the other side to agree to change its behavior, to give you a letter saying, I know I was wrong and I'm sorry. You can get them to agree to do things differently in the future. Those are things you could get in settlement that you just can't get. You know, I was representing some moms a while back whose children were abused in a daycare. It was a heartbreaking case.
Jeez.
And those moms cared much more that this daycare changed the way that it does things, the way that it hires, the way that it trained to make sure no other children would ever be put through that,
Yeah.
than they cared about the dollars that they could get in damages at court. So sometimes, even if you have really great facts, what you want, you can only get through settlement. And sometimes even if you've got a strong case, you just don't want to have to deal with it,
Yeah.
right? As a fighter, as someone who sees conflict as intimacy, this is not in my DNA, but there's a lot of people who are conflict averse,
Yeah.
who don't want to fight. And so they let me do it for them, but they also would rather get out with a little bit of a haircut or a little bit of a compromise than have to fight all the way through the court system. You know, and I believe in the jury system, Kevin, through and through. But it can be really scary to put your fate in the hands of 12 strangers.
Yeah. That's a great way to put it. We always hear about, jury of your peers and all this stuff, but it's 12 strangers. I mean, let's be honest.
Yeah.
Yeah. The daycare example is horrifying, but also a great example of a situation where you would want to take it to trial to get so to make sure people know about this, to hold them accountable, maybe even get them shut down if they need to be. So like, yeah, I could totally see why you would take something like that and say, no, we're going all the way. We're getting as much attention on this thing as possible.
But then you also can't say, okay, you're going to implement this training process and you're going to implement this hiring process and you're going to put cameras in every room, because those are things you can get with a settlement.
Okay. That's interesting. Okay. See, okay. This is why you're the lawyer and I'm the podcast host. You said you like, you kind of thrive on the conflict, right? You like fighting for people. How does your trial experience directly shape the way you negotiate before a trial?
That's a really great question. And one of the things that we see now, and it's, if you Googled it, you would find out it's pretty rare to get to go to a civil trial anymore. It's expensive, it's costly, and what ends up happening is partners haven't gone, so they haven't trained associates to go, and then those associates become partners who've never gone. And what that creates is some insecurity around the idea of going to trial. It's very nerve-wracking to guide your client to a place you've never been. And so having the trial experience that I have allows me to say, I know what the end looks like, and I know I can do it for you. So I'm not afraid to say, hey, it's in your best interest to settle this because your client is absolutely in the wrong, and we're going to drag them through the mud. But if you don't see it that way, I'm ready to go. Let's go. And that puts me in a position where my opposing counsel knows they're not going to scare me on the eve of trial. They're not going to scare me from wanting to go to trial. Most of the time, I would rather be in trial than settle, but sometimes that settlement is in my client's best interest.
Sure.
So, and as a fiduciary, I'm going to do what's in their best interest. But going into it, knowing how to go to trial, which means I'm getting those jury charges, I'm being guided from the beginning. I have a strategy. I spoke to a potential client several months ago who was complaining that many of the lawyers he was trying to work with were just cowardly about trial. And he said, I'm tired of hearing we're going to land in Normandy and then see what happens. I want a strategy. Right?
Wow.
And
Okay. Yeah, that's not what you want to hear.
no, right? And I'm not a litigator. I'm not here for the discovery. I mean, I am a trial lawyer. So we're going to do all the things we need to do to get what we need to take your case to trial. And if along the way we set you up well to settle favorably, we can do that.
Mm-hmm.
But you're not going to find cowardice on my end or a fear of going to trial that's going to push you into a settlement that isn't good for you.
Mm-hmm.
You want somebody who knows the game, who's been there, who knows how to fight, and can lead with that strength from the beginning.
Well, this is our 4th episode. I can already tell that you're a trial attorney. Definitely can see that. It's awesome. I love hearing that. Are there risks in settling too early or perhaps too late?
It's pretty rare. I would say that it's risky to settle too early. If you're getting something early on where the other side is willing to really be reasonable, it's probably in your best interest to take it. And oftentimes that's before you filed suit or they have filed suit. It keeps you out of the public eye because court filings are public.
Sure.
Right? And so it keeps you from having that, oh, someone Googles my name and it turns out I was a defendant in a lawsuit, or it looks like I allow sexual harassment at my company, or, in the case of a recent case I had, an employee walked out with everyone's W-2s, and now trying to get a job when there's a lawsuit that alleges that is pretty difficult.
For sure.
So, settling early is much less risky than settling late. And, if you have the opportunity to come forward with a reasonable solution, again, coming from the woman who wants to fight, it's better to take it early because then you have fewer costs. You've spent less on your lawyers and less on your costs like experts and depositions and those things. And you don't have the pain of having been in it for that long.
Right.
I have found that settling late often means both sides get less and everybody's a little less happy. But, sometimes settling on the courtroom steps is still better than spending the time and money. A trial day for me is usually about 16 hours and I bill by the hour. So you're talking about 16-hour days for however long that trial is going on. You're paying your experts, you're paying for staff, you're paying for meals. It's not an inexpensive endeavor.
No, it's not. Wow, that's intense. Is there an example that you can share where a strong trial posture changed the negotiation dynamic?
Yeah, absolutely. So, like I said, a lot of litigators are used to fighting the case to a settlement and coming in and being ready to go to trial, having your ducks in a row, being laser focused during discovery on what you need. In more than one occasion, I have seen it really change the way that the other side looks at the case. They understand we're not here to play. We're not here to just, prolong this and maybe negotiate around. We know what the law is. We understand what facts we have. We've covered our weaknesses. And because of that, you're going to lose. And so it's in your best interest to come forward with a reasonable settlement. The law also allows, both federally and in Texas, for something called an offer of judgment. And what that does is it says early on, hey, I made you a reasonable settlement offer. I told the court I made you a reasonable settlement offer. Here it is. If you want to take it all the way, even though this is really, a good offer, and the jury gives you 80% or less of what I offered, you're going to walk away with nothing because you should have taken a reasonable offer. Or on the other side, if the jury doesn't give you 120% of what I demanded, doesn't give me 120% of what I demanded, then you have to pay my attorney fees because you should have given me this reasonable offer.
Mm-hmm.
And I find that's a strategy that can be really powerful when you're dealing with an opposing party, like the one I mentioned earlier, who was just so convinced this jury was going to give him his money, right? And the answer is they're not. And you drug us through this and you shouldn't have. So you're going to walk away with nothing.
Mm-hmm. Wow. Is it tough sometimes to, when you have a strong feeling, obviously you're the expert, and you have a client who is like, really wants to settle, and you don't think that's the best option, or vice versa, where they really want to take it to trial and you don't think that's the best option. Is it difficult for you? Because obviously it's their choice at the end. How do you balance knowing what's best versus making sure you do what's right for your client, or should say what your client wants?
Yes. Yeah, it is hard, Kevin.
Yeah.
It is really hard. And I'm passionate about my clients and their businesses. I care about them deeply, too much sometimes, probably. And so it is hard to watch them make a choice
Yeah.
that isn't great. I had a client recently who, because of some things that were really kind of outside their control, breached a contract, and the other party was willing to let them sell rather than walk away. And it would have been a pretty sizable sale. And because of personal emotional reasons, they just couldn't make themselves do it. And that is a really hard position where you think you are walking away from maybe $1 million because of your emotions.
Yeah.
And I can't make you do this and I can't make it look different, but at the end of the day, I am the fiduciary for you, and it's your case and your life. And, I will say there's a caveat there where we take things contingency. If I've invested in your case, usually those engagement letters say I get a choice of whether we settle or we go all the way. And so that does change the dynamic a little bit
Sure.
because I only get paid if we win. But most of my work is on an hourly basis for my clients. And so the power is theirs to stay or to go.
Is there a sense sometimes for people that settling equals losing?
Yes. And I think it's such a myth,
Yeah.
right? We've already talked about settlement can get you things that a trial court can't. Settlement can get you out, get you the time value of your money, get you back into doing what you do, which is not litigating. And oftentimes it's a good outcome. And I say that again, knowing it's not my favorite outcome most
Right.
of the time, but often it's a really good one. And I think you can have a little bit more control over your destiny when you're choosing to do it in an agreement than when you're leaving it in the hands of the court.
Yeah. Well, we talked before about 12 strangers.
Yeah.
You don't know where their kind of, tendencies lie. You don't know how mad they are that they have to be there at in the jury. You know what I mean? They'd rather be doing something else. So you are, I mean, you're a lot of times you can be rolling the dice, but at the same time, it makes sense. Like what you're saying, if it's a contract, you can negotiate the contract and have a say in what happens. You don't have
Yes.
as much of a say when it goes to trial, but you could still get more. So I could see how that's tough for a client. But to me, if I'm in that situation, if I hire a lawyer that I trust, I would lean on the lawyer.
That's exactly right. And if you hired a lawyer who's never been to trial, Kevin, they're going to say we should settle.
Yeah. Yeah. That's a good point. Yeah. I mean, that's the thing, right? There's some lawyers that just settle. That was like a part of A Few Good Men. The movie I remember is
Right.
like, he was always settling. He had never seen the inside of a courtroom. That was the joke. So like, is that common? Are there lawyers that just don't ever want to go to trial?
Yes. And there are lawyers who just have never really gotten the opportunity. And as you get
Wow.
more and more senior, that gets harder and harder to fix. And so, it's unfortunate because litigation is so expensive and so risky. Just not that many cases go, but it's a bit of a chicken and an egg. Do they not go because your lawyer's never gone and so now less are going? Or is it,
Mm-hmm.
you're not going and so lawyers aren't getting trained?
Yeah.
But for those of us who went to law school to be in the courtroom, which was my goal, and I've been able to get there, I know that I can guide clients in and around the court. And, the jury system works most of the time. The research backs it, but that's hard to convince someone still that what is the right outcome and how do I trust it to them. But if you have a good lawyer who can guide you, who knows how to do jury deselection, who knows how to ask the right questions, and who knows how to work that process, you're going to be in much better position to fight for justice in the courts.
Mm-hmm. Yeah. Interesting stuff. All right. Well, thanks for tuning in to In the Courtroom and the Boardroom, Business Law and Litigation with Colleen McKnight. To connect with Colleen and the team, visit mcknightlaw.us, and don't forget to subscribe to our channel. We got lots more great information coming your way. Colleen, it's always great having you here. Thanks so much for the conversation.
Yeah, Kevin, thanks for letting me talk about the thing I love the most other than my family.
Absolutely.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.